'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Might be coming down for sure.
When liability can arise as part of an agreement, we're going to move on to a second area of liability that is very important to business law, and that's liability associated with negligence. Now, this is important because this can arise even, say, if you don't have a contract. And we want to specifically look at what do we do when our actions might cause harm to other people. So to think about it a different way, when might we have to be careful? And to help us do that, we're going to look at torts and the tort of negligence. So if we're going to understand this area, we need to know what a tort is and the specific tort of negligence. So to be negligent, there are three requirements that we're going to do. This particular module, we're going to look at duty of care, and particularly where we owing a duty of care. And then in the next module, we'll look at breaching that duty, causation, and some of the defences. Now, we've already seen that you can have one incident, such as, say, me punching you, which I would never do, but if I did, well, I'm not saying I'd never do. Anyway, you get the idea. If I had to punch you, then we can have one incident and several particular legal problems arise. One of them can be a criminal problem, that of assault for me, but we could also have what's called a tort. And so what we want to understand, if we go back to what we discussed in Module 3, that there are these different areas of law that give rise to different kinds of liability, and they have different rules. And so this is a different area of law from contract. It's the area of torts. And I really want to stress this idea that when something goes wrong in business, there's often not one legal or a singular legal issue involved. There's various types of legal liability. So we have this incident, and it might lead to being liable for torts. There might be something under a statute. We might be liable under a contract, etc. So this is one particular area that we're going to look at, and an element of torts, negligence. So tortious liability has to do with harmful acts. It's a civil wrong, so it's not a criminal issue. It's a civil, so we know that means it's between two private individuals, okay? And it's where someone causes harm to another person, and that would give them the right to compensation. So it's the provision of a remedy because it's private or civil law. It's a remedy, not a punishment. Okay? And sometimes a single act can be both a tort and a crime. Tort is primarily case law, but recently it has been codified, or should I say, some elements have been codified. So what we're going to see is a mix of cases as authority and statutes, depending upon the area of tort that we're dealing with. So if we look within tort, there are various areas. We're going to specifically look at negligence, but another area of tort is trespass, where you interfere with someone's property. And also we have misrepresenting someone's reputation is the tort of defamation, which you might run across in business as well, and even in the press. We're seeing that more recently. So what exactly is the tort of negligence? Well, negligence is where you carelessly cause harm to someone else. Now, not every time you carelessly cause harm are you liable for it. And that's what separates, say, carelessness and an accident that arises from carelessness from negligence in the legal meaning of the word negligence. We're talking about careless acts that meet the standards required to be defined legally as negligence. That's when legal liability actually arises. So negligence involves a failure to protect the interests of someone whose interests you ought to be concerned with. That becomes important later. It was first put as the neighbour principle, okay? So it's not only about a mistake or carelessness, it's beyond that. It's a failure to protect the interests of someone who you ought to have protected, okay? So negligence can arise if you carelessly cause harm to someone else, and it's the most common tort. It's more than carelessness. You must objectively fall short of what society expects. So like all areas of law, we've seen that it develops over time. And what we can see here are some of the very major highlights in the development of negligence. You see, there wasn't always this action for negligence. And what we see at the beginning is an idea of trying to get this, something like owing a duty of care to people, into the law, which really crystallizes with the famous case of Donahue and Stevenson. There's a number of reasons as to why this occurs. One of them is the Industrial Revolution. You see, prior to that, if you're not mass producing things, pretty much most of the harm caused by products, etc., and negligence would also be covered by contract, right? Because you would make it and sell it. But what happens when you when someone else makes something that you resell and that causes harm? You know, the person who's on selling it might not know about the problem, and they might not be responsible for the problem that actually occurred. So the law was looking for a way to make those people liable. That was one of the key drivers behind it. And that was really the issue behind Donahue and Stevenson, as we'll come to see. And that gives rise to this idea of the neighbour principle, that you need to take care of those whom you might reasonably be thought able to affect their welfare. That, of course, gets adopted into Australia with the Australian knitting mills. But it becomes so broad that everyone starts to get a little bit worried about what they're actually liable for. And so we see some codification where we see Parliament step in to try and put some limits on negligence through legislation. They were particularly worried about affordability of insurance for many professionals who were being found liable for large, unsustainable levels of damages for negligent misstatement, which we'll come to, an important part of negligence. So what we have was the Civil Liability Act replacing aspects of negligence. So it replaced breaching the duty and causation, elements 2 and 3, but not owing a duty, number 1, which remains common law. So historically, the law of negligence traditionally consists primarily of case law or common law sense 2, but following some legislative reforms, the law of negligence is now a combination, and our relevant statute is the Civil Liability Act, the CLA 2003. Now, you're probably going to get sick of me saying this, but there are 3 requirements to be negligent. First, the defendant must owe the plaintiff a duty of care. If you don't owe a duty of care, you cannot be negligent. Second, the defendant must have breached that duty of care. Okay. Third, that breach must have caused the harm. You must have all 3. If you don't have all 3 elements, you are not negligent. Just because you owe a duty doesn't mean you're negligent. You also have to breach that duty, and that duty must cause the harm. And we're going to go through those elements and how we work them out specifically over the next couple of modules. First, in this module, we're going to look at when do you owe a duty of care. It's probably one of the most difficult areas. It can be the most difficult area to understand what it actually means and the implications that arise from it. So we're going to look at that requirement, number 1, owing a duty of care.